I'm often asked about what we call DUI drugs. In other words, a drunk driving case where you're not accused of having too much to drink, but you're accused of taking drugs or some kind of medication that's impaired your ability to drive. These kind of cases fall into two basic categories: recreational drugs and medicine. Either one of them can be the basis for a DUI drug charge. In terms of recreational drugs, especially the illegal ones, you could be found guilty of that if it's proven that you have any measurable amount in your system of drugs such as cocaine or marijuana. Now, just because a lab report comes back and says you have those kind of drugs in your system, that doesn't mean you're guilty, because their machinery is not necessarily that sensitive. So don't just assume that a bad lab report means that you're guilty. Talk to an experienced, qualified lawyer. The more complicated situation, and the one that I often have to deal with, is where you're taking medication and you're taking it the way your doctor prescribed it, but they're accusing you of driving while drugged. Some medications will impair your ability to drive, and if you take them as the doctor prescribes them, you shouldn't be driving on them. Other times, the medication won't impair you, or the medication impaired you, but in a way that was not voluntary. That can also be a defense. So if you're accused of DUI drugs or operating while under the influence of drugs or medication, you need to talk to an attorney who's really skilled in this area, who's qualified to evaluate your situation. Give us a call. We're here to help you, or submit an online case evaluation request, and we'll go through your specific situation.